During the research of ESA, I've found another unnecessary hardship that landlords might have to endure. In this statement of interest by the Justice Department, in some legal matter where a party didn't know English and was not going to have an English speaker in the unit, the person was refused an apartment for rent. We found out that this is something that the Justice Department wants all landlords to have to go through. From the Department of Justice, dated Friday, April 1st, 2022. Justice Department filed statement of interest in Fair Housing Act case alleging unlawful exclusion of tenants who do not speak English. The Justice Department filed a statement of interest today in the United States District Court for the Northern District of New York, explaining how policies that exclude rental housing applicants because that they do not speak English may violate the Fair Housing Act. The statement of interest was filed in CNY Fair Housing versus Switch Village LLC, a lawsuit alleging that the defendants violated the Fair Housing Act FHA by refusing to rent apartments to applicants who are limited English proficient (LEP), unless someone who speaks and reads English lives in the unit. The defendants own and manage the apartments in DeWitt, New York. The lawsuit further alleges that the defendants refused the applicants' offers to bring their own interpreters to translate lease documents and assist with communications. Refusing to rent to people who do not speak English makes finding safe and affordable housing especially hard for people who come to the United States from countries where English is not the primary language, said Assistant General Kristen Clerk of the Justice Department's Civil Rights Division. When housing provides ban prospective tenants who do not speak English well, their actions may violate the Fair Housing Act, which prohibits discriminations based on the national origin, race, and other protected characteristics. As we celebrate the Fair Housing Month, the Department of Justice underscores its commitment to fighting for fair housing across our nation and assuring that housing providers respect the federal civil rights of people who do not read or speak English fluently. The right to housing is fundamental to full participation in society, said U.S. Attorney Carla Freeman for the Northern District of New York. When landlords engage in practices or enact policies that desperately impact people who have come to America from non-English speaking countries, these actions must be strictly scrutinized for potential violations of the Fair Housing Act. My office is proud to partner with the Civil Rights Division in regard to this matter. Hood commends the Justice Department for pursuing the housing rights of these who call America home, said Demetria L. McClain, Hood's Principal Deputy Assistant Secretary for Fair Housing and Equal Opportunity. Relying on recent census data, CNY Fair Housing's complaint alleges that the defendant's LEP exclusion policy imposes an unjustified, disparate impact on the basis of national origin and race. The complaint also alleges that the defendant's restrictive language policy was a pretext to discriminate against applicants based on their national origin and race. Among its protections, the FHA prohibits discrimination in housing on the basis of national origin or race. The statement of interest explains how a restrictive language policy may violate the FHA when it has a disparate impact or is used as a proxy or pretense for discrimination based on national origin or race, as alleged in plaintiff's complaint. It also discusses how the plaintiff's allegations are consistent with the Department of Housing and Urban Development's guidance on Fair Housing Act protections for persons with limited English proficiency, which clarifies how restrictive language policies may run afoul of the FHA. Seeing why fair housing versus Swiss Village was filed in the Northern District of New York on November 2021, the defendants have moved to have the case dismissed. Seeing why Fair Housing opposes that motion, and the Justice Department statement of interest agrees with that the dismissal of the complaint would be inappropriate. The motion is now pending before the court. So what could be some reasons the landlord didn't want to rent to a non-English speaker? Landlord might want someone they can communicate with. If an issue or dispute happens at the apartment complex, how would the landlord resolve that issue? If something does happen, the Justice Department might say that the landlord took advantage of the non-English speaker and knew the renter didn't know English. Or if the landlord or someone needs to communicate to the tenant to leave or stay put due to some emergency, the landlord will be at fault for not having a full-time interpreter on premise since they knew that the person didn't know English. This is a no-win scenario for the landlord. How does the landlord not putting themselves in an obvious trap is making it hard for the apartment seeker to find safe and affordable housing? No other place in the city is safe and affordable? How is that the landlord's fault? If the Justice Department focused more on actually justice, maybe people wouldn't be doing crime, making the city unsafe. Anything just to point the finger to somebody else. The Justice Department liked to state discrimination based on national origin and race. How does that relate to not renting to someone who you can't communicate with? The seeker was a non-English speaker. It didn't matter where the person was from, nor the person's race. Just bringing up race and nationality just weakens the case when this is an actual issue. The request from the landlord was to have someone that spoke English in the unit. This isn't a rejection on where the person was born or born into. It was a rejection based on skills. I too wouldn't want to rent to somebody I can't communicate with for the same reasons as stated. How do I know if the person understands me? How would I even really know if the person understands the agreement? What if there's a time where the tenant would have to communicate an issue where it can be shown, like having to pay the rent late? Do I have to be able to speak and write in every language? What other businesses forced or even threatened with suing to serve a person that they can communicate with? If a person comes into a restaurant and starts speaking some language somebody doesn't know, is the restaurant forced to serve that person just something even if they can't understand the person? This shouldn't be forced on landlords to do the impossible. This statement or article from the Justice Department site is dated April 1st, and hopefully this was just an April Fool's joke and nothing serious. Unfortunately, there's a greater chance this is a serious, they're really serious about this statement. After writing my comments, I searched for more information. Case text has something on this. It's listed out some of the testing CNY had did in test 1. It pretty much says what I stated here. Butler was the rental agent from Swiss Village Apartments. This case states, Butler also asserted that she needed to be able to communicate with the client about the rental application and about work orders or any issues with the apartment. In this case, CNY just keeps claiming refusal based on national origin and race. Just BS to cheapen or weaken when there is a real case of discrimination. Unfortunately, the motion to dismiss was denied, and there's a chance now that every landlord needs to know every language in existence, being real or made up. Who knows, maybe some guy who wants to speak Klingon, I'm just gonna have to know Klingon, and if he has an ESA targ, well, damn, I gotta take that too.
Much behasta, Dutch?
Much behasta, Dutch, Miss Roy.
How much for these apples? Hijama Gia Ko.